Hi, Jennifer Scott here at Burnham Law, and I want to discuss how to successfully navigate a dissolution without a lawyer. Maybe you can't afford a lawyer, or maybe you just don't want to give your money to a lawyer. And so this video is going to be really helpful to you because I'll give you some tips about how to successfully navigate a dissolution pro se or without legal representation. My first tip is you have got to educate yourself as much as possible about the overall process before you even start. And a great resource is the Colorado court website, specifically the domestic court forms. Check it out. It's got, pretty much every template that you're going to need to use in your divorce. It's got a petition, it has sworn financial statements, parenting plans, separation agreements, the whole gambit. So check that out. It's a really great resource. There's also a handy flow chart that just, for visual people shows beginning to end the general steps of a divorce. And then finally, and my favorite part is there's an instructional, step-by-step packet, and it gives you details of exactly what steps you need to follow, what needs to be filed, beginning to end for your dissolution. That includes the definitions of terms, so you're not thrown off by the legal jargon. It has descriptions of filing fees, etc. And now I want to talk to you about some of the issues I run into with people who try to navigate their divorce pro se. There's just a couple of, common mistakes that you really need to avoid. And the top two that I've selected include not really understanding the law, the divorce law or the allocation of parental responsibility law in Colorado, and not complying with the rules. And next, I wanted to point out that a lot of people don't know you can get the benefit of legal advice without actually retaining a lawyer. The common perception is, well, you lawyer up, this person is filing motions and appearing in court and litigating on your behalf. That's when that's what it means to retain a lawyer. You can actually get the benefit of working with a lawyer and not retaining one. And that's called an advisory basis or a limited capacity representation. And the attorneys at Burnham Law do this all the time. It's really, really valuable for pro se parties because you get the benefit of the legal mind, strategy, brainstorming, someone you can ask questions to or, just troubleshoot with, but at a reduced retainer because you're not fully retaining. So now specifically what I see when a pro se party is doing their divorce is not understanding the law. And this is what I see happen. They have a false, preconceived notion, I guess I'll call it, of what the law is. For instance, there was a trust or a family business that existed before the parties got married. And a pro se party just assumes, okay, well, that's not part of this divorce. I'm not entitled to any of that, which is actually not true at all. So what would be helpful if you met with an attorney on an advisory or limited capacity is to have that attorney explain the law to you, but more importantly, how it applies to your case. Because without that understanding, how can you advocate for yourself? You could very well be giving up, waiving your interest in something you didn't even know you were entitled to in the first place. The next example that I want to offer about it was mistake number 2, not following the rules. Specifically, I see a lot of problems with 16.2. That's the mandatory financial disclosures that have to take place in every single dissolution. What happens is you've got two people, they're at the kitchen table, they're filling out their sworn financial statement, and they're maybe pulling up screenshots of account balances on their phone, or they're looking at the family computer screen and saying, oh, okay, this is what the retirement's worth, or this is what my bank account says, here's my credit card debt right now. Then they do a really great job entering into a separation agreement, parenting plan, everything. The problem is that they get to court at their non-contested hearing date, and the judge is looking through all their documents to make sure everything's in line. Perhaps they come across a business or a trust. They say, oh, I see there's a trust. Was everything disclosed? And the parties say, well, no, we have an understanding that that's going to be mine. And I told her all about it or told him all about it. And, it's not up for grabs. So we're okay. The agreement is fine. Just enter it. The court's going to pump the brakes. it doesn't matter if you both agree that I trust what you said and I don't want any interest in that. That's not the point. The point is 16.2 is a formal disclosure. And if you don't do it formally, it doesn't count. And then all of that hard work you did entering into your separation agreement is for naught. And you kind of find yourself back at square one, which is super frustrating. So just to kind of go over everything one more time, my tip is to educate yourself as much as possible. Check out the Colorado court website. And then the two mistakes that you should avoid is understanding the law, specifically how it applies to your case, and understanding the rules and the exact things that you have to do to fulfill the requirements of those rules. Hope this was helpful. Bye.